I thought that anyone looking to improve their drafting style might find it helpful to consider a couple of issues relating to how the legal profession generally approaches contract drafting. The first issue is one of quality. It's a common view among commentators on legal writing that of the various kinds of legal prose, legal drafting is the most problematic. And this really applies across the board because at the biggest and best law firms, even they produce contracts that are full of archaisms, redundancies, inefficiencies, and the other problems of ineffective drafting. The next issue is one of process. The bulk of contract drafting has always been done by junior associates, and generally they're expected to learn on the job by regurgitating model contracts of questionable quality. Often a draft that an associate produces will be distributed internally for review, go back for revisions, be reviewed again, and before you know it, you're at version 15 and the draft hasn't even gone to the client yet. So it's more than just a question of quality, it's also a question of dollars and cents, because someone has to pay for all that inefficiency. With their static budgets, their growing responsibilities, and their increasing outside counsel costs, company legal departments are starting to squawk. So what can one do about it? Law firms treat contract drafting as if it were craft. Instead, it should be an industry. It's highly likely that for purposes of a first draft, the contract you need for a given transaction will be very similar to the contracts used in countless other transactions. So with off-the-shelf software, a rigorous house drafting style, and readily available legal expertise, it would be pretty straightforward to put together a document assembly engine that would reduce the bulk of contract drafting to a commodity process. The impact of such a system could be very significant. But in the interim, what's the young lawyer to do? I think that essentially you consult the best authorities, you learn what good drafting is, and you also learn that you're not a slave to the prevailing practices. But you have to also realize that the pressures of practice are such that you're not always going to be able to turn that indifferent model contract into a thing of beauty. You have to be able to distinguish what's important from what's merely